G'day everyone, and welcome to the fifth and final video for week 6 of our admin law course. This has been a huge week, but we're just about done. All week we've been looking at the grounds for review. We've seen that a decision is invalid if it involves an error of law, if the decision maker fails to take into account relevant evidence, or if they take into account irrelevant evidence. A decision is invalid if there's no evidence for a key fact. It's invalid if the power is used for the wrong purpose. We've learned about discretionary decisions and the fact that discretionary decisions are not made properly if they're made in bad faith, if they're made at the behest of another person, or if they are simply the inflexible application of a policy. In this final video, we round out our grounds for review by talking about Wednesbury unreasonableness and uncertainty. Now, from the very start of this course, we made the distinction between legal review and merits review. Legal review asks whether a decision was made properly in accordance with the rules. Merits review asks whether the decision was any good. And since then, we've really only talked about legal review because the common law and the ADJR Act only apply to legal review. So the courts are not interested in trying to decide whether a decision was any good, but they are interested in deciding whether a decision was properly made. The thing is, it's possible for a decision to be so bad on the merits, so completely out there on the merits, that the decision amounts to an error of law. If a decision is so bad that there must be an error of process sitting somewhere underneath it, it makes sense for this to be considered as an error of law, an error in the way the decision was made. Because the rationale is that if any sensible process had been followed, the decision could never have been made. The formulation for this comes from a famous case called the Wednesbury Corporation against Associated Provincial Picture Houses. A decision is bad in law if it is so unreasonable that no reasonable decision maker could have made the decision. The ADJR Act uses almost exactly the same words. Section 52G says that a decision is bad in law if it is an exercise of a power that is so unreasonable that no reasonable person could have so exercised the power. Now let's look really carefully at those words. It has to be so unreasonable that no reasonable person could have so exercised the power. It's extreme. In the Wednesbury case itself, a case which revolved around the validity of a council rule that a cinema could not admit children under 15 on Sundays, the plaintiff failed. On virtually every occasion when the matter has been raised before the court, it has failed. The leading attempt in Australia is a High Court matter named Minister for Immigration and Ishitu. Mr. Ishitu was an asylum seeker who had escaped from Ethiopia. His evidence was that he had been part of a student protest movement against the government and that he had been arrested and beaten as a result of his protest activities. His asylum claim was refused, and he claimed, and the full court of the federal court accepted, that the department had not properly turned its mind to the circumstance of his arrest and imprisonment. The High Court, however, disagreed. Justice Gleeson and McHugh famously said, "Someone who disagrees strongly with someone else's process of reasoning on an issue of fact may express such disagreement by describing the reasoning as illogical or unreasonable, or even so unreasonable that no reasonable person could adopt it. If these are merely emphatic ways of saying that the reasoning is wrong, then they may have no particular legal consequence." So there has to be an actual flaw in logic, not just a severe disagreement. So we're left wondering what would reach the threshold of Wednesbury unreasonableness. It would really have to be out there. The best made-up example I can come up with is that if a decision maker rejected an application because it was Friday, and they always rejected every application they received on a Friday, well, that would be Wednesbury unreasonable. But the moment that there's any logic at all, any logic whatsoever supporting a decision, Wednesbury unreasonableness becomes difficult to prove. In all likelihood, if Wednesbury unreasonable decisions are made, they're probably not going to get to court. It's much more likely that internal review of the decision within the department will result in the decision being reversed. So in your assessments and in your actual practice, don't jump in to claim Wednesbury unreasonableness. For some reason, students love claiming Wednesbury unreasonableness, but it's almost never seen in the wild. A decision is Wednesbury unreasonable if it is so unreasonable that no reasonable decision maker could have made the decision. Now at last we come to our final ground for review, uncertainty. Section 5.2h of the ADJR Act says that an exercise of a power is invalid if it occurs in such a way that the result of the exercise of the power is uncertain. Now you've already met this concept of uncertainty when you did contract law. At law, something is uncertain if no reasonable meaning can be attached to the words, or if some crucial aspect of the decision is left out. A made-up example might help here. Imagine if a commercial fisher obtained a fishing licence and the fishing licence said, commercial fishing activities under this licence are limited to the area prescribed in the schedule to the licence. Now that kind of makes enough sense. A regulator might well want to say you can fish here, but you can't fish there. But now let's imagine that through some oversight, no schedule actually gets attached. In that situation, the power would be uncertain, wouldn't it? It wouldn't actually be clear at all what the fisher was entitled to do and what they weren't entitled to do. A really instructive example of uncertainty in action comes from a case called Ballarat Broadcasters and the Australian Broadcasting Tribunal. In that case, the tribunal wanted to increase the amount of Australian music being played by radio stations right across Australia. They issued a decision to all radio stations which said, although incentives will not be offered for the broadcasting of new recordings, new independent material and station-originated music which the tribunal wishes to encourage, it proposes at licence renewal to request stations to supply evidence that they have used a significant amount of this material. If stations cannot demonstrate the use of this material, conditions may then be placed on a licence in order to encourage the use of new releases, new independent recordings, and station-produced material, depending on the relevance of this material to the station's format. Ballarat broadcasters felt this decision was completely uncertain. The court summarised their concerns like this. Are they required to broadcast new recordings, new independent material, and station-originated music, or are they not? If they fail to broadcast such material, will they be under threat with respect to a renewal of their licence, or under threat of the imposition of some special condition? What is a significant amount of such material? Does the material have relevance to the particular format adopted by each applicant? Can you see that while the tribunal's heart was clearly in the right place, no radio station could look at the decision and actually understand their obligation? The decision was uncertain. Okay, so this has been a huge week of material. We've looked at a heap of different grounds for review over the last 3 weeks. We know that a decision is invalid if natural justice is not given to anyone sufficiently affected by a decision. We know the decision is invalid if it's not authorised by an enactment, if the wrong person makes the decision, or if some process or precondition has to exist before the decision-making power comes into effect, but that condition doesn't actually exist. We know that the decision is invalid if there's an error of law. We know it's invalid if there's no evidence of a key fact, or if the decision-maker either ignores relevant evidence or considers irrelevant evidence. We know the decision is invalid if it's made for an improper purpose. We know that discretionary decisions are invalid if they're made in bad faith, or if they're made at the behest of another person, or if there's simply an inflexible application of policy without considering the individual circumstances. We know decisions are invalid if they are so reasonable that no reasonable decision maker could have made the decision. And we know that decisions are invalid if they are uncertain. Those are the grounds upon which we can challenge the lawfulness of a decision. But if we're successful, what happens then? That's what we're going to turn to next week. We're going to look at remedies under the common law, at equity, and under the ADJR Act. For now, congratulations on surviving week 6. Watch these videos over and over. The week 6 videos are the heart of the course. It's all downhill from here.